Hello, my name is Kathleen Flynn from the law offices of Kathleen M Flynn in Decatur, Georgia. We assist adults and children in obtaining SSI benefits, SSDI benefits, disabled adult child benefits, widows and widowers benefits, and veterans service-connected benefits. Today I'll be discussing what happens to the claim when tragically our client passes during the long delays, particularly these days during the COVID pandemic, at the initial reconsideration levels. In Georgia, everything was shut down for many months, and Georgia was one of the last 5 states to be operable at the initial and reconsideration level. Pre-COVID, last March to 2020, Georgia had already been sending a lot of the cases out to other states to be handled by adjudicators, although the consultative exams were still scheduled in Georgia by the DAS in Georgia. That's an exam with a state contracted psychologist or physician. However, the files were worked up by adjudicators in other states. Now, they're still doing that post-COVID because of the huge backlogs, but the problems we're seeing now is the out-of-state adjudicators are taking a long time to adjudicate these cases. Whereas pre-COVID it would take 3 to 6 months, now it's taking a year, 7, 8 months. We just had a claimant die who was in hospice, and we notified the out-of-state adjudicator that he was terminally ill. We provided the hospice records, the most recent hospitalization, and still a decision wasn't made before he passed. So what do? Unfortunately, we had to contact the son in the midst of his grieving to ask if he could be a substitute party. So who else could be a substitute party besides a daughter or son if an SSDI claimant passes before a decision is reached by the Social Security Administration at the initial reconsideration hearing level, appeals council level? Some people think that a brother or sister could step in the shoes of a Title II claimant who's passed, particularly if the brother or sister was kind enough to take care of the deceased claimant, but unfortunately that's not the case. Some other substitute parties could be a parent of a deceased SSDI claimant, also a surviving spouse who was living with the claimant at the time of his or her death, or a surviving spouse who was entitled to monthly benefits on the deceased Title II claimant's record, and that would have to be inquired into at the district office level to see if the spouse was entitled to monthly benefits. And lastly, someone who administered the estate of the claimant, and there's certain requirements which I won't get into in this video because it'll be too technical. But just as a broad overview, someone who administered the estate of a Title II claimant. Next, I'll move on to who could be a substitute party for an SSI claimant. An SSI is welfare, and because it's welfare, there are fewer options for a substitute party. I guess the government wants to restrict who can obtain these welfare benefits if an SSI claimant passes. And SSI is filed based on income and resources of a claimant. And again, it's a welfare claim. So one substitute party could be the deceased spouse who was living with the claimant at the time of his or her death, or supposing if the claimant were in the hospital or hospice, they look at the 6 preceding months before the death of the SSI claimant, and also a blind or disabled child who was living with the claimant at the time of his or her death, or preceding the 6 months prior to the death of the SSI claimant. So I hope this gives you an overview. Once there's a substitute party established, a death certificate has to be obtained and substitute party documents have to be completed. They're fairly basic with the name, address, phone number, and relationship of the claimant noted on the form. However, if these documents are not submitted, the case could be dismissed. And they have to be submitted in a timely manner before the case is dismissed. Usually if we alert the adjudicator or the judge, the hearing office, before it gets to the judge and before the hearing is held, they'll give us sufficient time to supply these documents. The Social Security Administration will also provide a nominal fee to help bury a deceased loved one, and the surviving spouse or child could be entitled to this fee with certain requirements met, and the amount is approximately $255. I'd suggest that you contact the Social Security District Office for more details. However, we'd be happy to help you if you have any further questions about being a substitute party in a case, or other questions about Social Security, disability, or veteran service connected benefits. Please contact us at 404-479-4431 or visit our website at www.kathleenflynnlaw.com. I hope you learned something from this video and have a great day.